So, good morning, everybody. Thank you for joining us to learn how to prevent evictions during this terrible pandemic. What the focus of today's presentation is going to be how to help tenants prepare their legal documents online to fight their eviction. My name is Jim Berchtold. I am the directing attorney at the Consumer Rights Project at Legal Aid Center of Southern Nevada. Also with me today are Lauren Pena. She is the directing attorney at the Civil Law Self-Help Center, which is located at the Regional Justice Center downtown, and Ryan McConnell, who is a staff attorney here at Legal Aid Center. So while I'm presenting, they will try to answer the chats and vice versa. So hopefully we can stay on top of them. All right, so again, thank you all for joining us, and we'll go ahead and get started. Maybe. All right, so what are we talking about today, really? And why are we doing this? So because of COVID, the entire country is facing a flood of potential evictions. So estimates are that 20 million Americans right now are currently behind on their rent. That's equal to the entire populations of Nevada, Colorado, Oregon, Utah, Wyoming, New Mexico, Idaho, Montana. Just to put some context to that number, if everyone in all of those states was behind on rent, that would equal about 20 million people. So it's a huge problem. In Nevada, the estimates are that anywhere between 142 households to 218 households are potentially at risk of eviction due to COVID. So it's a huge issue. Now, this project is to instruct people how they can help tenants defend against an eviction. Because the reality is most tenants in Nevada get evicted simply because they receive an eviction notice and don't take any action in response to it. So this is how you can help. So what are we going to cover today? The big picture thing we're going to cover is this awesome new online program. It's called a guide and file program that is now available where tenants can go online, answer a series of questions, prepare their court documents, and in some cases, just press a button and file with the court. I mean, it's really, if you think of it like a TurboTax for evictions, that's really what it is. It breaks the whole process down into easy little questions that the tenant can answer, and at the end of it, they can file their documents. So it's a really awesome way for tenants to defend themselves in this terrible time. So I am going to cover generally evictions in Nevada. How does the process work? We'll talk about the current eviction protections that are in place, and then we'll talk about the different types of evictions you might see as you assist tenants through this process. And then we'll talk about the general eviction process in Nevada. How does an eviction flow through the court system? Lauren and Ryan will take the next section, and they will actually walk you through one of these guide and file interviews to show you how easy it is to help a tenant prepare their court filings. Okay, so the first thing I want to talk about is Nevada's eviction ban. What protections are currently in place to protect tenants? Now, if you've been watching the news at all, you probably know that there have been a series of protections in place. They started at the federal level with the CARES Act, that expired. Then Governor Sisolak issued some moratoriums. Those have expired. Then the CDC issued an eviction ban that is still currently in effect. The CDC ban was issued mid-October in order to stop evictions nationwide. It's effective through the end of the year, through December 31st. The protections under that CDC ban are not automatic, meaning it doesn't simply apply to every tenant. The tenant has to take some action to get those protections. So the tenant has to sign a declaration and deliver it to their landlord. That declaration basically says that I can't pay my rent due to COVID. I've tried to make partial payments. I've tried to apply for rental assistance. I make less than $99,000, and oh, I left off 5. And 5 is I will likely be rendered homeless or forced into a group living situation if I am evicted. Unfortunately, the CDC declaration, the whole CDC order, didn't quite work as we had hoped it would. As tenants started utilizing it, it appeared that the court was taking a very narrow view of what evictions that CDC order actually prohibited. So a lot of evictions over the past month have gone forward. In Las Vegas alone, there were some 4,000 evictions, and that's with an eviction protection in place. So on December 14th, Governor Sisolak came out with a new statewide protection for tenants. That protection lasts until March 31st of next year, and it is somewhat based on the CDC order. So it's very similar to the protection that was already in place. But again, the protection is not automatic. And this is where we really are asking for everyone's help. Our big fear right now is that tenants will see in the news, it's been widely reported that there's a new eviction ban in Nevada. We are afraid that tenants will see that and think, oh, great, I'm protected from eviction. My landlord can't evict me until March. That is absolutely not true. And so we really are asking for your help to get this word out through your community organizations, through the people that you come into contact with, through your social media. We need tenants to know that they have to take action to protect themselves under this governor's ban. All right, so who is eligible for that protection? Under the governor's new directive, a tenant is eligible if they are unable to pay their rent due to COVID, and that could be their hours have been cut, they've been laid off. 2, they make less than $99,000 in 2020. For a couple that files jointly, that would be $198,000. 3, they are likely to be rendered homeless or forced into a group living situation if they are evicted. So those are the Nevadans who are eligible for this new protection under Governor Sisolak's ban. But again, it's not automatic. The tenant has to take some action. The tenant has to sign a declaration and give it to their landlord. That declaration basically verifies all of those eligibility criteria. It's a simple form. The tenant doesn't need to fill out anything. All they need to do is sign it and give it to their landlord. If the tenant has already given a CDC declaration to their landlord, they don't need to give another one. Governor Sisolak's directive makes clear that those CDC declarations will protect the tenant under this statewide ban. If the tenant hasn't given a CDC declaration yet, they should. They can sign a CDC declaration and give it to their landlord. Those declarations are widely available. They've been translated across the country into multiple languages, and they are also available on our website, which is www.lacsn, Legal Aid Center of Southern Nevada.org/COVID-19. There's a lot of COVID-19 resources there, and one of those resources is this CDC declaration, which will now be used to protect under the statewide ban. As the CDC declaration expires at the end of the year, if it expires, there's some question about that. It's being discussed in Congress right now. We may end up changing that declaration, but if the CDC declaration has been given, it's still good. So please get the word out. Now, what is prohibited? under this new statewide ban. Most of the problematic evictions that we were seeing, the evictions that were kind of escaping the protection of the CDC moratorium, are now protected under this ban. So we're hopeful that it will be fairly broad. But there are some evictions that aren't prohibited. Evictions for nuisance, if the tenant is conducting some type of illegal activity on the property, if they are damaging the property in some way, those evictions can still go forward under Sisolak's ban. Evictions for lease violation can also go forward under this new statewide ban, unless those lease violations are related somehow to rent, late fees, penalties, or other kind of payment issues. So some evictions can go forward, but the main ones we were worried about are now protected. Governor Sisolak has also built in a new kind of exception that a landlord can seek. The landlord can actually challenge the tenant's declaration, and frankly, they could do this under the CDC order as well, but now it's built into Governor Sisolak's directive. So the landlord can actually serve the tenant. When the landlord serves an eviction notice on the tenant, they can serve another notice that says, I intend to challenge your declaration. Basically, I don't believe that you're actually entitled to these protections. I think you have not told the truth in that declaration that you signed. And then the landlord can go to court and try to prove that. The landlord can also seek an exception if they can show that there is a realistic threat that that rental property is going to be foreclosed upon before the ban expires in March. So those are the two new exceptions that are built in. But as I said, generally, it's a pretty good protection. So these are really the big ticket things I want you to take away. We have a lot more to cover, but I want to hit this right out front. Really, we want to get this message out to tenants that if you are eligible, sign the declaration and give it to your landlord. There is no downside to this. There is no sense in waiting. There is no reason to wait. And if you haven't, and there's no time limit. So if you haven't, you still can. Make sure for tenants, they need to keep a copy of that declaration for themselves, give a copy to the landlord, but keep a copy for themselves. They also need some kind of proof of service of how and when they gave it to their landlord. So on our declaration form available on our website, there's actually a proof of service form that the tenant can fill out when they give the declaration to their landlord, saying how they delivered it, to whom they delivered it, when they delivered it. So the tenant will keep both of those things, because if the landlord should move for eviction, the tenant will want to submit those in their court case to show the court that they have taken this action. Okay, so that's the first thing. The second thing is, if the tenant receives an eviction notice, they must take some action and file with the court. A lot of tenants are thinking that, well, I gave the CDC declaration to my landlord, so I don't need to worry about this eviction notice that just got posted on my door. That is absolutely incorrect. And I'll explain more about why that's incorrect. But if a tenant takes no action, they could get evicted automatically. So they have to file this answer with the court in response to that eviction notice to tell the court that they intend to fight this eviction. And that answer form is the form that we are going to talk about creating today. The third thing we really want to emphasize is that if a tenant is struggling, they should apply for rental assistance through the CHAPS program. There is still money there. Right now, that money, that's federal dollars, have to be used before the end of the year, but everyone is hopeful that that deadline will be extended and that more money will go into that program for rental assistance. So the process can be somewhat frustrating, and it may not be the quickest process in the world, but if a tenant is struggling, they absolutely should apply for rental assistance. There's a link to the CHAPS application on our website as well. Okay, so now let's dive into evictions a little bit. So every eviction in Nevada starts the same way. It starts by the tenant receiving a notice that tells the tenant what the problem is. This is the reason the landlord wants to evict you. That notice can be put on their door. Sometimes they receive it by mail. Sometimes it's actually handed to them. But that's the way the eviction process starts. Now, there are really two types of notices. There's a one-part notice, meaning the tenant will receive one document, and that's the only notice they'll receive. And there are two-part notices, meaning the tenant will receive two separate documents over a span of time. All of the notices are for different reasons and have different time periods. So the one-part notices, the big one you'll see is the notice for non-payment of rent. That is a 7-day notice. The tenant will receive one 7-day notice, or they may receive a 30-day notice of non-payment of rent if the property is covered by the Federal CARES Act, meaning that it's got a federally backed mortgage or it participates in a federal housing program. So those notices, they are one-shot notices. The other one-shot notice is a 5-day unlawful detainer notice if the tenant's lease has expired. This is pretty rare, but a landlord can, immediately after a lease expires, serve a tenant a 5-day unlawful detainer notice to get the eviction process started. Now, importantly, both of these notices, in the notice themselves, it will tell the tenant, you need to respond to this notice within this time period. So if the tenant reads the notice, it will be really clear. Now, the other parts of the other types of notices are the two-part notices. So the first part of each of those notices basically just tells the tenant, this is what the problem is, and I want you to leave. Either sometimes they get to fix the problem, but basically it's this is the issue and I want you gone. The second part of the notice is called an unlawful detainer notice. And that notice essentially says, I already gave you this other notice and you didn't leave the property. So now I'm giving you this unlawful detainer notice saying you're unlawfully on the property and I'm going to move to evict you and you need to take action to prevent that. Okay, so we'll talk a little bit more about that, but these are the two-part notices. A no-cause notice is a notice that the landlord gives, basically just saying, you haven't done anything wrong, I just want my property back. Importantly, this notice can only be given if there's no lease agreement. If there's a valid current lease agreement, that contract protects the tenant. But once that lease agreement expires, the landlord can serve a no-cause notice to try to get the property. So there are two no-cause notices. If the tenant pays rent monthly, they could receive a 30-day no-cause notice. If they pay rent weekly, they could receive a 7-day no-cause notice. That's the first part of the notice. Once those time periods run, the tenant will receive a second part of the notice, which is the 5-day unlawful detainer notice. And that notice will tell the tenant, you have 5 days to fight this eviction, go to the court, file something to fight this eviction if you're going to. Okay, so the next two-part notice is a tenancy at will notice. These are pretty rare. You probably won't see this very often, but a tenancy at will notice is really used for guests, kind of. So let's say I invited somebody to stay with me, and now they're refusing to leave. That person is a tenant at will, and I can evict them on a tenancy at will notice. So that's a two-part notice. They would receive a 5-day notice telling them to get out. If they don't get out, they would receive the second 5-day notice, which would say, you're unlawfully on the property, and I'm going to move to evict you, and you have the right to file an answer. The third notice we're going to talk about is a nuisance notice. A nuisance notice is used when the tenant is doing something wrong on the property. They're conducting some illegal activity, they are damaging the property in some way. That is a 3-day notice that will say, this is what you're doing that I don't like. Then there's a 5-day notice that says, I told you, I wanted you gone, you're still on the property, you have 5 days to fight this if you're going to. The last notice is a lease violation notice. A lease violation notice is a 5-day followed by the 5-day unlawful detainer. The first 5-day will say, this is how I believe you are violating your lease. Now, importantly, with the lease violation, the tenant actually has an opportunity to fix that if they can fix it. The landlord says you're violating the lease by XYZ. And tenant does XYZ. They fix XYZ. That should avoid the eviction. But if they get the second part of that notice, the second part is the same 5-day unlawful detainer notice that says, I told you there was a problem, you're still on my property, I want you gone, you have 5 days to file something with the court. So notice that the second part of this notice is the same for all these notices. It's the notice that says you have 5 days to file with the court. Okay, so this, I know you can't see it, it's really small, but this is the first part of the notice of the 5-day notice because the tenant has violated the lease in some way. 5-day notice to perform lease condition or quit. So if you can see my cursor, there's a couple of things I want to show you that are important on this form. Now, this is the form from the Civil Law Self-Help Center. The form that the tenant actually may receive may look a little bit different than this. The landlord might create their own form, but statutorily under Nevada law, the form has to contain certain information. All right, so here, this is going to be the tenant's name and address. This is the landlord's name and address in this section. Now that's important because when you're filling out the answer form that Lauren and Ryan will talk about later, you want to make sure that the tenant is telling you what information is on this form. They may deal with Fred in the office, but Fred's not the person who's going to be on this notice, probably not. So, so that's important. The other thing I want to point out, all right, so down here, there's a space for date of service. On the first part of this notice, that's not too important, but it is important on the second notice. All right, so the tenant would receive, let's say the tenant violates their lease, they would receive this 5-day notice to perform lease condition. It basically says, you have violated your lease, you have 5 days to get off my property or fix this condition. So the 5 days run, landlord is still unhappy with the tenant and wants to move forward with eviction. So the landlord would serve the second part of the notice. So this is the second part of the notice. This is the 5-day notice of unlawful detainer. And this is the same notice that the tenant would receive for all those 2-part notices. And what it says is, you received a notice, you didn't do anything, you are now guilty of unlawful detainer. You're unlawfully detaining the property. And so I am going to move to evict you. You have 5 days to go to court and file an answer to fight this eviction if you're going to. If you don't, the eviction could be granted automatically. Now on this form, as I said, there's going to be a date of service. That's important because that's how you know how to count the 5 days. So after the 5 days pass, the tenant has no right to file an answer to fight this eviction anymore. So counting the days is important, and we'll talk about that a little. All right, so 1-part notices, which is basically the big one, is the non-payment of rent. It's a 7-day notice for non-payment of rent. The tenant can answer during that period, during the 7-day period, until the court closes on the last day. The 2-part notices, the tenant would let the first part of the notice run, then the tenant would receive the second part of the notice. Only during that second period can the tenant file with the court. So the tenant cannot file during that first period. They have to let that first notice run. When they get the second, they can file with the court. So timing is crucial. So the way you count that time period is by counting judicial days, which are basically days that the court is open. So right now, the justice courts where evictions take place are open Monday through Thursday. So you don't count the day the notice was actually delivered to the tenant, you don't count that day. You don't count Fridays, you don't count Saturdays, and you don't count legal holidays. So let's say, for example, a notice was served, a 7-day non-payment notice was served on the 3rd. So you wouldn't count the 3rd. The 4th would be day 1. This is a holiday, so you don't count that. You don't count Friday, you don't count Saturday, you don't count Sunday, because the court's closed. So don't count date of service, Next day would be day 1, day 2, day 3, day 4, day 5, day 6, day 7. I hope that makes sense. If you ever have a question about how to count the notice, you can always call our office and we'll try to help you walk through the notice. But again, it's pretty simple. Don't count the date that the notice was served. The next day is day 1, and you only count the days the court's open. All right, so quick summary of the notices. So rent is 1 part notice. It's a 7-day notice. Right now, rent notices are banned for qualified tenants to March 31st under the statewide directive, meaning that if the tenant has given a declaration to their landlord, they should not receive a rent notice unless the landlord intends to challenge that and can try to convince the court that the tenant isn't really entitled to the protection of the ban. No cause notices. There's a 30-day for tenants who pay monthly. There's a 7-day for tenants who pay weekly. Those are 2-part notices. So after the first part, it will be followed by a 5-day notice of unlawful detainer. Those are also currently banned under the governor's directive if the tenant is qualified and gives the declaration. Lease violation, it's 5-day followed by a 5-day. Those are currently banned for qualified tenants who have given a declaration only if the lease provision relates to rent or payment. Nuisance notices, 3-day notice followed by 5-day unlawful detainer. Those are not banned right now. Tenancy at will, 5-day notice followed by another 5-day unlawful detainer, not banned. All right. So eviction starts with a notice, then what happens? So what we're going to talk about today is the summary eviction process. This is the process by which an eviction moves through the court. So it's called the summary process because it is. It's fairly quick, it's fairly easy, it's really designed so that landlords will be able to do this on their own. But it's also designed so that tenants will be able to appear on their own. So it's pretty rare that you actually see a lawyer in eviction court, for example, because tenants and landlords are appearing themselves. So one thing to note about summary eviction, it's only about possession. So even if the landlord is evicting for non-payment of rent, and the landlord says, you owe me $7,000 in back rent, the only thing that the court can do in summary eviction is say, tenant, you're being evicted, and landlord, you get the property. It does not award money. So the landlord would have to sue separately for money. All right, so all summary evictions, as we said, start by the tenant getting an eviction notice. They will get the eviction notice that relates to the reason that the landlord thinks they'll be able to evict. So to avoid eviction, during that notice period, the tenant has to file an answer. Sometimes it's called an affidavit, but we'll call it an answer. That's generally what it's called. The tenant has to file an answer with the court in order to protect themselves and basically notify the court that I intend to dispute this eviction. Now, this is where you come in. So this is where you might be able to help that tenant avoid eviction by utilizing this new online program and helping them prepare an answer form that gets filed with the court. After the tenant files the answer form, or after the time for the tenant to file the answer form is passed, then the landlord can file a complaint for eviction. So it's a little weird because the person being sued, the tenant, is the one who actually files first, and then the landlord files second. So during the notice period, tenant can file. After the notice period, the landlord can file and say, I want an eviction. So if the tenant didn't file during that period, what happens? If the tenant didn't take any action, didn't file anything with the court, then basically the eviction gets granted automatically. It's called a straight eviction, and it's eviction that's granted without a hearing. The court just looks at the paperwork and issues the eviction order. The eviction order gets sent to the constable. The constable will post that order on the tenant's door and will return in 24 hours and lock the tenant out of the property. So that's if the tenant didn't do anything to protect themselves. Now, what happens if the tenant did file an answer? Filing an answer guarantees the tenant a hearing in front of the judge. So nothing can happen until that hearing. And importantly, it doesn't even matter what the tenant says in the answer. There are a lot of defenses that the tenant might be able to raise depending on the type of notice that they received and the situation, but it doesn't really matter what they say. As long as they get an answer on file, they are guaranteed a hearing in front of the judge. So when the landlord files the complaint, a hearing will be scheduled. This court will send out a notice of hearing that will have the hearing date. Now, a new development that we've been working on is eviction mediation. So this mediation only applies if the tenant receives a non-payment notice. So if the tenant receives a notice of non-payment, when they file their answer with the court within that 7 days, they will be able to elect mediation. They say, I want to participate in the mediation program. And that case, the hearing in that case will be set out 30 days so that there's time enough for a mediation to take place. The tenant will be notified of the mediator. They will need to register online with the mediation program that's being run through the state, and they'll receive instructions on all of this. But basically, they'll have an opportunity to sit down with a mediator, the landlord, the tenant, and a neutral mediator sit down to see if there's some way that they can work out an arrangement to keep that tenant in the property, whether that's repayment of back rent, whether it's some other creative solution. Potentially, it's rental assistance through CHAPS. So if you are assisting a tenant who has received a non-payment notice, they should elect mediation. There is no downside to mediation. If it doesn't work, it doesn't work. No harm, no foul. But it might, and it extends the eviction process out. So if a tenant does file an answer, as I said, they get a hearing. The hearings are pretty informal. It's usually the landlord, the tenant, the judge, and really what the judge is trying to determine is whether the tenant has a legal defense to that eviction. If the tenant, so if the tenant doesn't have a legal defense, or let's say if the tenant does have a legal defense, then the eviction will be denied. Meaning that the landlord does not get the eviction, the case will be automatically sealed in 10 days so that other landlords can't see it. And the landlord really then has a couple of choices. They can either they could appeal, or they could pursue the formal eviction process, which is a totally another process we're not going to talk about, or they could just wait and serve another eviction notice to the tenant and start the whole summary process all over again. So that's if the eviction is denied. If the eviction is granted at the hearing, that means that the judge will issue an eviction order. It will go to the constable will post it on the tenant's door. The constable will come back in 24 hours to lock that tenant out of the property. Now, before that lockout happens, well, let me step back. If the lockout happens, the tenant's done. There's no way to get back in the property. There's nothing the tenant can do to save that tenancy. But before the lockout happens, there are a couple things the tenant can do. The tenant can file a motion to set aside, which is basically the tenant telling the court, I think there was some legal mistake made. I have a legal reason that this eviction shouldn't have been granted. Those can be a little tough for a tenant to win. It's not super common, and it doesn't necessarily stop the eviction. It can stop the eviction if the tenant raises some legal reason that the judge wants to talk to the tenant about. The judge can set a hearing and stop the eviction process until that hearing, but it's not guaranteed. The other thing a tenant can do is file a motion to stay. Now, a motion to stay is really a motion to get a little bit more time on the property. So it's not a motion to permanently stay on the property, it's a motion to delay leaving. So all the court can do on a motion to stay is grant the tenant up to 10 additional days to leave the property. The court doesn't have to grant anything. It could deny it and the tenant will get nothing. Or the tenant could give, or sorry, the court could give any number of days up to 10. The other thing that a tenant can do is appeal. Now, all evictions are heard in the justice court. An appeal is the tenant saying, I believe this decision is wrong. I'm going to appeal it to the next highest court, which is the district court. To appeal, there is a $97 filing fee. If the tenant has filed a fee waiver saying I'm indigent and I can't afford this filing fee, that filing fee can be waived. Importantly, though, there's also a $250 cost bond that the tenant has to pay. So the tenant literally has to give $250 to the court clerk. That money is the thing that stops the eviction until there is some decision on the appeal. So appeals can be very effective, but it's hard for tenants sometimes. If a tenant is having a really hard time paying their rent, then it's really hard for them to justify coming up with $250 to pay the district court. But that amount can't be waived, and that's the thing that stops the eviction. Okay, so that is basically the summary eviction process from start to end. So just to go over it one more time, every eviction starts with a notice. The notice is served to the tenant. Within that notice period, the tenant can file an answer with the court. That's where you all will hopefully come in and help tenants so that they can prepare that answer with the new online program and get it filed. After the notice period runs, the landlord can file a complaint for eviction, asking the court to issue an eviction order. If the tenant has filed an answer, then a hearing is going to be set. If the tenant hasn't filed an answer, then a straight eviction can be granted. Tenant doesn't get a hearing, eviction's automatically issued. If the tenant receives a non-payment notice and has requested mediation, mediation may be built in there somewhere. If the tenant has filed an answer, there will be a hearing set where the judge will either grant the eviction or deny the eviction. If the eviction order is granted, it will be sent to the constable. The constable will post it on the tenant's door, will come back in 24 hours to lock out the tenant. Before that lockout happens, the tenant can try filing a couple of different types of motions, or the tenant can appeal. Once the lockout happens, the eviction's over and the tenant's done. All right, so that is my portion of the presentation. So I am going to turn this over to Lauren Pena, directing attorney at the Civil Law Self-Help Center, and Ryan, one of our staff attorneys. And they have been practicing their thespian skills to show you how to walk through this new eviction prevention program.
Thank you, Jim. Great presentation. And good morning, everyone. Thanks for being here today with us. As Jim said, I'm the directing attorney of the Civil Law Self-Help Center. And Ryan McConnell, would you like to introduce yourself?
Oh, there we go. Yeah, my name is Ryan McConnell. I'm a brand new staff attorney here at Legal Aid Center. I'm working on the eviction prevention program.
Great, thank you, Ryan. So I'm going to share my PowerPoint with you. And
there we go.
Got it. Okay. So I'm going to be presenting the portion with Ryan about how to use the Tyler Guide and File program that Jim was mentioning. So what is the Tyler Guide and File program? You see the next slide?
Yep.
Okay. So like Jim mentioned, it's a program like TurboTax for legal documents. So it lets the users from home, from the comfort of their own computer, even phones, answer a bunch of questions. And at the end, the forms populate and they can actually be filed with the court. So the beauty of this, especially in this pandemic, is that people don't have to leave their home in order to file a response with the court. So the two interviews that are completely integrated with Las Vegas Justice Court, and when I use the word integrated, I mean these are the two interviews that can actually be start to finish done from home, are the tenant's answer interview and the proof of service of a CDC declaration. And we're going to talk about both those interviews today. This is the website that you will hopefully be using a lot with people to help them get through the process and file from home. So a couple of important things that I just want to highlight before beginning. And a lot of this will make more sense when we go through the actual exercise of going through the answer. The first thing is register, 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 and do that from the beginning. Register your user, the tenant, as soon as possible because it saves all the information entered into the interview. If the information doesn't get saved, you have to start all over again, and nobody wants to do that. The program works best on Google Chrome. So if you can do it from a PC, that's the best thing. Many people try to do it on Internet Explorer. It's possible. It's just not really great and compatible. So use Google Chrome. When we go back and make changes, you'll see you'll just have to, in order to capture the changes, keep hitting next through all the pages so that every change is adapted. And I'll explain more about that as we go and show you how that works. So like I mentioned, these interviews are completely integrated with Las Vegas Justice Court. So if a tenant is renting in Las Vegas, this interview is going to take them from start to finish. However, if a tenant is renting in North Las Vegas or Henderson, there still is a lot of value to this interview. The only thing is at the very end, they'll have to save their PDFs and email those PDFs to these two addresses on the screen, North Las Vegas and Henderson. But still has a lot of value because it's the interview, as you'll see, is great at telling you what needs to be filled out and make sure that things are populated in the right portion. The other thing that I just want to reiterate that Jim mentioned several times, timing is everything. And the reason I say this is because I know that there might be a little bit of fear of like, oh, what are we putting in this answer? Is it the right defense? Are we choosing the right thing? If you get an answer lodged within the notice period, you're guaranteeing that tenant a hearing and you're guaranteeing that that tenant won't be evicted without the opportunity to talk to a judge. So sometimes a tenant might list things in the interview that you're kind of like, oh, I don't know that that's going to help them. An answer timely filed is 100 times and 100% better than no answer timely filed. So just get them in on time. And we have a script that Ryan and I are going to kind of go through that you can modify according to your own pace and style. But I think that it's going to be helpful in terms of speaking with the tenants who generally have a lot of information to share, and not all of it is going to be relevant to the interview. Okay, so now I am going to share with you the interview, and here we go. So when I call scene, Ryan, who is a new attorney at Legal Aid, but in previous life was a thespian, going to be playing the role of our tenant today. And if you look closely, you'll notice that Ryan has been mistaken many times for Jason Bateman. Is that right, Ryan?
I mean, at least once. At least once. I'll take it though.
I got Margaret Cho once, which I was surprised by, but I think most Asian people have been mistaken for Margaret Cho at some point. Anyways, I'm going to be, I asked Ryan what this was yesterday. Is it breaking the third wall or the fourth wall?
Fourth wall.
Fourth wall. So I'm going to be talking to you all as we go through this, but Ryan is going to stay in character as our tenant. So this is a list of all of our interviews that we have through the self-help centers, the Family Law Self-Help Center, the Civil Law Self-Help Center. You're going to be focusing on these two today. And that's what we're going to be going through. And a reminder, these are the ones that are integrated. So if you see one on here and you're like, oh, I want to help somebody file a small claims counterclaim, that's great, but it's not fully integrated for filing. So anyways, we're going to start here. This is the website, as you'll see up here, the address that we go to. I'm going to choose Summary Eviction Tenant Answer, and that's going to get me started. But remember, the first thing we're going to do is register. So here I go, and what I'm going to do is pretend that I'm calling Ryan as he set up an appointment with me, and we're going to go through the interview together. Okay, so Ryan, scene. Ring ring.
Hello.
Hi, this is Lauren from Legal Aid Center of Southern Nevada, and I'm calling for Jason Bateman. Am I speaking with him?
Hi, Lauren. Yeah, this is Jason.
Hi, Jason. May I call you Jason?
Yep, that's my name. That'll work.
Jason, I see that you've signed up for an appointment with us. So I'm going to be asking you a series of questions. And based on your answers, I'm going to complete an online interview with you. At the end, we'll be able to file your answer with the court. And this will be in response to the eviction notices you received. Just as a reminder, I'm not your lawyer, so I can't and won't be giving you legal advice today. But because we only have a half-hour slot together, I just want to make sure that we get this filed on time. So I'm going to ask that you give me the briefest answers possible to your questions. Does that work for you?
Yeah, that'll work. I'll do my best to be brief, and I really thank you for your time.
Thank you, Jason. Okay, so I have your name as Jason, Jason. Is that correct?
That's correct.
And your last name, Bateman?
Yep.
And would you be able to tell me your email address, Jason?
My email is, well, it's pretty simple. It's Jason, my name, Jason, 1983 at AOL.com.
I love a classic AOL address.
Back when they had the discs.
And Jason, we're going to be making up a password for you today, just for this program. And to all of you watching out there, when you're doing these en masse, if you have several appointments, what I found to be useful is I just picked a theme that day that made things more fun for me personally, like what's your favorite fruit? Other days I chose colors, others I chose Halloween candy, whatever gives me joy that day. So today I'm going to say, and there are certain qualifications for creating the passwords, characters, numbers. So because I know that, it moves faster for me to just say, Jason, what's your favorite fruit?
Oh, my favorite fruit?
Yeah.
Oh, I guess I'll go with pineapple.
Pineapple, a goodie. And I'm creating a password for you. And at the end, I'm going to give you a couple of things that we'll need to write down. But for now, I'm just going to keep asking you questions.
Oh, okay.
And Jason, this number that I called you on, is this the best number for the court to reach you if they have any questions?
Yeah, this is my cell phone, the 580-4557 number.
Great. And will you tell me your address where you are renting and receive mail?
Yeah, my address is 1001 Ozark Lane.
And is there an apartment number or building number?
No, this is a house.
Great. And it's in Las Vegas, correct?
Yeah, it's in Las Vegas, and it's 89167.
Thank you. Oops. Oh, sorry. In rehearsal, we created an email address for Jason Bateman. So guess what? I'm going to age you one more year.
Ah, devastating.
It's okay. Jason Bateman, like many people, get better with age. So
Really ageless.
He really is. And has more range as he gets older. And if you haven't watched Ozark, which is the inspiration behind this tutorial, you should. And you'll see that you've been registered because the email address pops up here. Something good to notice, if you don't see an email address up there, stop right there and register. And you can register at any time during the interview. Okay, so a lot of these initial screens are informational. I suggest that when you play around with it before you take on actual tenants, read through them. And tenants who are doing it themselves should absolutely read through these start pages. But for the sake of this exercise and to move quickly, I'm going to kind of fast forward these. This is actually a very helpful informational video that will guide you through how to actually work this. It's probably as fun as watching me and Ryan play this part, but it is also very helpful. Understanding self-representation, of course, because we're not their lawyers, as they fill this out themselves. It's going to tell you what forms will populate and what information they'll need. And then, so we already know, he said that the city is Las Vegas, where the rental property is. And Jason, you said you're living at Ozark Lane and you received a notice in regards to Ozark Lane, right? You're being evicted from your home?
Yeah. I got 2 notices actually.
Okay. So I know he lives there. I'm going to choose residential tenant. Now I'm going to stop here and show you what a tenant would be looking at. Ryan, do you see that notice? Jason, do you see that notice? I'm sharing my screen. Can you see an lease file?
No, it's still on the guidance file.
Okay. Excuse me while I switch screens here. So what Jason Bateman is looking at is how about now?
There it is.
So Jason was served with a 5-day notice to perform lease condition or quit, which he's going to be looking at. For the sake of this exercise, I'm going to pretend like I can't see this. I would really suggest that if you have tenants who are able, ask them to screenshot pictures of the notice to you. It will move a lot faster because you can see exactly what they're looking at, and it's very helpful. So for Jason, he received this first 5-day notice to perform lease condition or quit. And as Jim noted, you'll see the reason why they're being evicted here. So this reads that this section of the lease agreement prohibits pets, and tenants are housing 2 birds and 3 hamsters. And a section of lease also prohibits unauthorized tenants beyond those listed in the agreement. And the landlord believes that there are additional people living there. You're going to get a lot of questions about, this is blank. Is this a real notice? The answer is, that's not for you to decide. That's for a judge to decide. Many times this declaration of service is blank, but the landlord has their version, which is actually all filled out, and you don't take chances on this file within the time period, right? So this notice, as we talked about, as Jim talked about, they're all the notices that are really not non-payment are 2 parts. So this one says, hey, you've got 5 days to fix these issues or else I'm moving forward with an eviction. So 5 days after, the landlord wasn't satisfied, still thought that Jason was housing hamsters. So what do? They serve Jason with the 5-day notice of unlawful detainer, which is part 2 of the eviction process. And you'll see that this is what he'll be looking at. There's the date of service. That means that the clock starts ticking the day after December 14th is when you start counting the 5 days like Jim went over. So again, this notice says, hey, file an answer otherwise, and here's a link to what you're going to be helping people with, and if you don't, you might get evicted. So let's go back to our interview that Jason's going to be playing the part of. Okay, are we back on the interview, Jason? Can you see?
Yep.
Okay, super. Okay, so this question, if he received 2 notices like that, or if he received the 7-day non-payment of rent notice, the answer to this is no. A summons and complaint is a formal eviction, which this interview isn't for. A summons and complaint will say summons and complaint. So if you don't see those words, the answer is no. And this question says, which of these notices were you given? Well, I already know from Jason, he got the 5-day lease violation notice, but you'll see that all the choices are here for the summary eviction. So just to clarify, Jason, you said that you received a 5-day notice to perform lease condition and an unlawful detainer. You got 2 notices, right?
Yeah, those are what they say.
Now, can you look at the 5-day notice to quit for unlawful detainer? And can you tell me if there's a date of service stamped on there?
Yeah, I think it's in red here. It's December 14th.
December 14th. So I know when I look at my trusty calculator, like Jim showed us, or not calculator, calendar. The 14th was a Monday. Tuesday, Wednesday, Thursday the 17th, Today is not a court day in Las Vegas Justice Court, so 21st, 22nd. I know by the end of the day on the 22nd, Jason needs to have his answer filed. So have more than 5 business days passed since that date? No. Jason, have you heard about the CDC halt or stop or pause on evictions?
Yeah, I gave my landlord Donna that a while ago.
You did.
I gave that to her. Yeah.
Great. Now, for this interview, if your tenant had not done it, you would choose no, and it would run you through additional pages to see if they qualify. For the sake of this exercise and moving it along, we're going to say that he's already given the declaration. But the interview will work both ways. Okay. Oops. And as we've all learned to become during COVID, just be comfortable with the silence. And yes, it is a bit repetitive. You have to type things in a couple of times just from difference between registration and the actual interview, the actual stuff that's going in the form. And Jason, is your rent subsidized by Public Housing Authority or any kind of governmental agency?
No, we pay it ourselves.
Okay. Now, when you look at your eviction notices, Jason, do you see another name on there? It's addressed to you, but is there someone else?
Yeah, it's addressed to me and my roommate, Laura Linney.
Okay. And Laura's a person, I'm assuming, right?
Laura is a person.
She is an individual. And is her name Laura and then Linnui?
Yep, that's correct.
Thank you.
Good guess on the last name. A lot of people spell it IE at the end.
Oh, well, they're not as cultured as I. And when you look at those notices, Jason, do you see the landlord's name?
Well, it says from the Ozark group. I always deal with Donna. Donna's the lady I always talk with, and she's just a real jerk. But this says the Ozark group. I don't know who they are.
Okay. But Donna's the property manager that you always deal with, but she's not on the notice, correct?
No, she's not on there.
Okay. So an important thing about filling this out is as much as possible, we want to match the information as it is in the notice. And that's because the clerks are going to link what the landlord files with what Jason files. So if he didn't have the notice or he lost it and he's like, I don't know what was on it, but I deal with Donna. Sure, he could put Donna, but what's going to end up happening is the courts are going to shuffle around a little bit and have to match it by address, which can cause some complications. So let's avoid complications and stick with what is on the notice so that it's consistent throughout, because we know the landlord's going to put that on their complaint too. Now, can you tell me what the address for the Ozark group is, Jason?
Yeah, they have a PO box 14365.
And is it in Las Vegas?
Yeah, it's Las Vegas, Nevada, 89110.
And is there a phone number for the Ozark group on there?
Mm-hmm. It's 702-580-5555.
Thank you. Now, this is the first defenses page. These are all the common defenses to a lease violation notice. Because I'm familiar with these, what I do is I hit none of the above, and I'll tell you why. I go to the next screen, What you can do is you can read through the laws and all the defenses and read them each individually to the tenant and say, which ones of these do you check? But I'll tell you what I do. I skip to the next page where this is the tenant's opportunity to tell me what their defenses are. And then it helps me go back and check the ones that I think will work. So what I'll do is this. So, Jason, I'm going to ask you for about 3 sentences. And in those 3 sentences, if you could just explain to me briefly what your defenses are, why you don't think you should be evicted, and why you think these notices are wrong, and what you want the judge to know. And I can only type exactly what you say to me.
Okay. Well, so the notice says I had 2 birds and 3 hamsters and someone else living with me, but I don't. My sister was visiting, and she brought her birds and hamsters with her, but only for one night, and then she left, so she's not here anymore.
With her,
So,
and only for one night.
so I think I don't think it's really about that. I think I've been having trouble paying my rent the last couple months, so I think that's what this is really about.
Ah. Thank you, Jason. Okay, so this pretty much fits in there, but if we had gone on for a little bit longer and you needed more room, what you can do is just cut this, say, yes, I need additional space, and then continue with your information down there. And all it will do is populate the form so that there's no overlap on text. So I'm going to hit next, but like I said, I now know what Jason's defenses are, or what he's trying to articulate as his defenses. So I'm going to go back to that one page where I chose none of the above. And instead of choosing none of the above, I think a good defense is the conduct of the landlord describes is not a lease violation because he was just having a visitor. Not a lease violation, a lease violation. I fixed the violation within 5 days. Well, if it was a violation, maybe you fixed it. So those are a couple of things that you can include. Again, what's most important is that you get this in timely. So I'm going to hit next. And then remember, like I told you, in order to capture that change, you just have to keep going through the interview and hitting next again. And what I mean by that is don't just go here and then skip this page and skip to general defenses. Just keep going through the pages and hit next. Now, another helpful thing that I want to note is this blue line right here. Look, we're almost done. You can see how far we've made it. So I know that, I've got 10 more minutes with Jason. I'm coming up on that. That's okay. We've probably only got a few more minutes left. Okay. Now, Jason, if the unfortunate situation did happen where you went to court and the judge still ordered an eviction, would you need more time to move out?
Well, how much time do they give me?
That's a great question. After the court hearing, the judge sends the order to the constable, who then posts the order on your door in about 24 hours. After they post that notice on your door, then they lock out within 24 to 36 hours.
Oh, so I basically have 2 days.
Could be.
So yeah, no, I've been in this house for 10 years. I've been hoarding all this stuff. I have all kinds of stuff in my basement. I have fancy equipment down there. I need time to get all of that out of there.
We can only ask for a maximum of 10 days. How many of those days would you want to ask for?
All of them, as many days as I can get.
Oops. And these are also defenses, I'm sorry, I skipped through that you can go through with the tenants and read them and see if they qualify. Based on, again, my familiarity with the interview, I knew that these probably weren't going to apply to Jason. So skip into the next page. And Jason, can you explain to me again in a couple of sentences why you would need more time to move out? You said you've been there for 10 years.
Yeah, I have 10 years worth of things in there, and I have most specifically, I have uh, a bunch of fancy audio equipment in my basement that I just need time to. You can't just throw that stuff out the window, and it's a basement window too, so that'd make it even harder. So
Ah,
I need all this time.
I need time to move out.
Yeah.
Okay. And how lovely it is that you have a basement in Las Vegas.
Well, it stays cool during the summer.
Oh, that's great. Okay, so no additional space needed. But if you are a fan of the show Ozark, you know that terrible things go on in that basement in the Ozarks. Okay, so Jason, you told me that you gave Donna a copy of the CDC declaration. How did you give it to her?
I sent it to her email.
Okay. And when did you send that to her?
I sent it to her on December 1st.
Ah, okay.
I think, yeah, December 1st.
And so this question automatically populates to, did they give it to the landlord who's on the notice? He's saying he didn't. He gave it to Donna, the property manager. Do you know Donna's last name?
No, she's just Donna.
Okay. Kind of like Cher.
Kind of like Cher. Yeah, she's much meaner than Cher, though.
Oh, I'm going to put Donna, property manager, here. If all you know is that her name is Donna, then you just put Donna. But what email address did you send it to?
Just donna@gmail.com. She must have joined Gmail early. I can't believe she got that one.
Well, she's not a classic like you, Jason. All right, so you'll see that the answer portion is completed. Now we have to start the filing fees portion. Jason, in order to file this answer with a court, it costs $71. Will you be willing to pay the $71 today, or would you rather ask the court to waive those fees?
Oh, no, can we ask him to waive it? We don't make much here.
We sure can. I'm going to ask you a couple of questions about your household income. Now, how many adults live in your home? Is it just you and Laura?
Yeah, just the two of us.
Okay, no children?
Nope,
And Laura is an adult, correct?
she is.
Okay. Do you get any public assistance or Medicaid?
Our income's from Social Security,
Ah, okay.
but no Medicaid.
So, and how much do you get from Social Security, the two of you?
Combined, we get about $1,400 a month.
Any other sources of income?
No, that's it.
Oops. All of these have to be populated with zeros. Okay, so we're gonna hit next. And Jason, you declare under penalty of perjury that everything you told me is true and correct, and you're unable to pay the filing fees today?
Yeah, that's correct.
Now, this page is a survey page, which is extremely helpful to us in terms of coming up with better ways to express ourselves and ask the questions. So if you have time, please encourage your tenants to fill out the survey or help them fill it out, because sometimes they're just very helpful in helping us share with courts how many people are actually using this and how much time it takes them and how useful and helpful it is, especially in times like this. But for the sake of today, I'm going to skip through the survey. Okay, Jason, it looks like we're all done. I'm going to start reviewing your documents, and then we'll be moving on to filing.
Okay.
And so these are all the forms that have been populated. You have to review every form before you file it, and you choose view, like I just did. I'll show you on the next one a little slower. But you'll see that everything's populated in here. It's been served with a performed lease condition. Here's his address. And just to triple check, Jason, your address is 1001 Ozark Lane. Your phone number is 580-4557, and email jason1982@aol.com.
Yep, that's right.
And you'll see that the appropriate portions of the form are filled out. Here are his offenses, and here's the statement that he wrote. The continuation is on the addendum. which is right here. And you'll see that it populates today's date that he's going to file, as well as his signature line. Now we have to, go back to the summary. We have to review the next document, which you'll see right here. This is his proof of service that he gave the declaration to Donna, and the right box is checked by email to Donna, the property manager, at the following address on such and such date. And you said you emailed it to Donna on December 1st, right?
Well, let me check. Oh no, you know what? I apologize. I emailed it to her on November 1st. It was a while ago.
Okay, no problem. So what we're going to do is go back to the summary. We're going to hit return to interview. And I'm going to hit this blue button that says completed, because I remember that it was in that interview where it asked me when we gave Donna the declaration. So what you just have to do is find the page where you entered that information. And I know it's on this page, proof of service page. So I pull that back up again, and Jason says he needs to change this to November 1st, 2020. And then remember, we have to hit next and keep going through the interview until it's completed. So that captures all those changes. And we have to go through this one again, but the information is not lost. All you have to do is click through. Next. Next. Oh, one other thing that I wanted to share with you. When going through that fee waiver, you may have noticed that Jason had told me how much money he had made. And one good thing to note is it's always up to the judge. There it is.
There we go.
So that's the Las Vegas Justice Court fee waiver guide. They go off 132% federal poverty level. So if Jason had told me, hey, together we make Social Security and we make $1985 together, I would say, I don't know if you're going to get approved for a fee waiver. So just be on the lookout that if you are denied, the court will be calling you and asking you to pay the $71, either by coming to court and paying in cash or by paying over credit card over the phone. There is an opportunity, if it's very close, for the tenant to plea with the court, make their statement as to why they aren't able to afford the 71. But generally, I knew that he and Laura made $1,400, which is $500 less than that standard. So I'm fairly certain, even though I can never really say because I'm not the judge, but I'm fairly certain he'll get approved. Okay, so back to the interview. Here we are, goes back through the survey, and we have made all those changes. So I'm just gonna have to review them and double check that those changes were captured. Here we go again. So you select, you can also download. If you are doing a North Las Vegas or Henderson complaint, download them, save them to PDF, and then that's what you're going to email. But for today, we're going to view this, and you'll see that all the information is still there. The answer wasn't really changed, so that looks good. I'm going to go back and review to make sure the proof of service was changed to, and sure enough, there it is, November 1st to Donna@gmail. And then here is the fee waiver that gets populated based on Jason's income. 2 adults, $1,400, signature, populated. Now, we reviewed it, so all these check boxes appear. The next thing we're going to do, hit next. All right, Jason, we're getting ready to file.
Oh, all right.
Now, you'll see here on this screen, It's telling what exactly the filings are going to be. These are just codes. The filing fees are waived. If you are paying, if a tenant is paying, it follows basically a regular credit card page. And we submit now. And then we just cross our fingers and hope that this interview works. All right. So this is an envelope number, which is very important. This is the one that you want to write down for your tenants. So what I'll say is, Jason, I'm going to give you 2 very important things to write down today, okay?
Okay.
The first is for your password. Your password is pineapple with a capital P.
Pineapple. I'm sorry, go ahead.
Pineapple with a capital P, 4567 #, or hashtag, as the kids say.
Okay, so capital P, pineapple, 4567 hashtag.
Yes, sir. And your envelope number is 711-3984.
711-3984.
Yes.
Okay.
In just a couple of minutes, you're going to get an email from the court at jason1982@aol.com. And Odyssey Guide and File is going to tell you that they've received your filing for processing. But in about 24 to 48 hours, you're going to get an email again that has your documents file stamped, and that means that everything's gone through. If you get any kind of email that says it's been rejected, well, then you'll have to call us back.
Okay. Okay, so right now we're done?
Right now we're done. The important thing you have to remember is just to look out for your email and look out for your mail. And you're going to get information from the court about your filings and when your court date may be.
Okay. Okay. Well, thank you very much, Lauren. This is much easier than going down to court.
You got it, Jason. Best wishes to you.
Thank you.
And see. Gosh, Ryan, you should not be a lawyer. You got to be you got to go back to acting. It's too good. Okay, so last things I'm going to share with you are just a couple more slides, and then we'll be finishing up. So I just wanted to give you a couple bits of information about legal aid. We assist victims of domestic violence, divorce, custody, TPOs, immigration cases, and we also have a consumer program, which Jim is in charge of, that helps with debt collection cases, payday loans, Social Security, bankruptcy, all that kind of stuff. On Legal Aid's website, at the very bottom, you'll see lacsn.org. On that website, there is a legal and financial toolkit, which is very helpful, constantly evolving with everything that changes every day with COVID. So we refer people to that all the time. Information about utilities, rent, anything that's going on that affects tenants right now, financially and legally, and eviction stuff. So keep checking on that toolkit, keep sending people those links. We do have free virtual community legal education classes. Anyone's interested in the small claims class, I'll be teaching that this afternoon. And we have telephonic Ask a Lawyer sessions. So every Wednesday, we have a volunteer lawyer who telephonically talks to tenants for 20 minutes each. And they can ask that lawyer for legal advice, how to proceed with their case, how to present their case in court, and all kinds of procedural questions as well. All of our services at Legal Aid are remote right now, so email, phone, all of it. And those are the numbers and emails you can use, 702-386-1070 or info@lacsn.org. And lastly, the Civil Law Self-Help Center, which is where I work. We provide self-help information to anybody who's unrepresented by an attorney in those civil cases. We call ourselves the Legal Emergency Room. Because we help with those kinds of emergency filings like these eviction filings, the guided online interviews, the ones that you saw, And in 2019, we helped more than 47,000 litigants. It's going to be higher this year, is what I can tell you. Our remote services are offered by phone and online chat. So we're open the same hours as Las Vegas Justice Court, 7:30 to 5:30, Monday through Thursday. So if you hop on our website, civillawselfhelpcenter.org, during those business days, you'll see one of our awesome agents on chat via the chat bubble. And you can always also call in during office hours at that number. We just want to really thank you all for being here today. We know you're doing such a great service to all the tenants who need you. And I've got a list of email addresses that I will send the PowerPoints to. And if anyone ever has any questions, of course, we're here to answer those for you. So thank you for all of your participation, and we so appreciate having you here today.